legislative actions happening in Georgia. So you should really be proud of your association and what it's done, and the strength of the association, including all of you that are here today. So it's something you should be involved in. If you're visiting for the first time, join the association. We need your help. We need to sort of send the message out there of the things that are happening. My goal today for the legal review is, as you well know, I want to make this fun and interactive. The room seems a little hot. You've had lunch. I don't want anyone nodding off, or I will sue you. And you have to laugh at my jokes, or I will sue you. So let's learn together for the time that we have. And the way I wanted to do it was to bring back, I can hear the excitement, self-storage Jeopardy. Now, for those of you who've been following Jeopardy in real life over the last few months, you know, got a lot of new news. The guy was winning all the time. How many of you watch Jeopardy? You know, like, okay, a few of you. The rest of you will not know the answers to these questions. I'm a little worried about that. So I thought I'd bring it back. We've done self-storage Family Feud. We've done self-storage Who Wants to Be a Millionaire. That seemed to have a lot of excitement when I did that one. So we're back to self-storage Jeopardy. The goal of this is for you to, there'll be questions you don't have to answer in the form of a question. I'm not that serious about it. But the topics are things that I know you are curious about and want to learn about and be refreshed about, including what has happened with the new lien law. So I am going to move to our panel, Lien Law, Leases, Auctions, Security, and General. And I want you to just call it out there and we will learn together. So,
Lien law.
Thanks, Ann. Thank you. All right. Lien law for what?
50.
Oh my gosh. All right. Lien law for 50. How much time should a facility wait before it overlocks a tenant unit for non-payment?
7 days.
I hear 7.
1 day.
I hear 1.
No, sorry, 8.
I hear 8. Oh my gosh, you are all going to jail. This is great. This is great. You need me. Thank you. All right. So, what does the statute say? What does your law say with regard to denial of access and the issue of default? So, the answer is overlock after 7 calendar days. So, Sarah Beth's right. The 8th day for overlock would be the legal answer to the question under the statute, under the law. Overlock. Tenant, why do I get this look on your face like I'm going to call my manager right now, let them in? Anybody want to challenge that? I mean, now we've talked about the fact that I know it upsets you between day 1 and day 8 that they're coming in and moving out and getting free rent. So that's been an issue of the fact that the statute talks about denial of access based upon default after 7 days, and denial of access would be the safest thing, the 8th day, after 7 days. Could you do a gate access denial, a vehicle access denial before 7 days, so that the tenant to access their goods, which are not overlocked until the 8th day, they'd have to come through the office. And why do they come through the office? Because you want them to pay. Huh. You get it. Can you do that? Yes, you can do that. You could do a gate access, a vehicle access denial, forcing them to come in through the pedestrian or through the office entrance if it's in your rental agreement. So those of you who are frustrated by me saying 8 days, maybe the first time you've heard that, this could be a solution to the problem if it's that much. Otherwise, it's not that big of a deal. You have the ability to deny access, which creates the motivation for people to pay after the 7 days, hopefully. All right. Whoops. Let's go back to this. Let's see if I do this right. You know, I'm gonna mess this up. I know I am. All right. Let's go back to the beginning.
That was for me.
That was for Sarah Beth. Yeah, there we go. Okay. All right. This all worked before. All right. Let me hear another one. Call it out. Security for 20. How much to? Oh, nope, that's not it. This is going to frustrate me. Sorry, guys. I've worked so hard on this. All right. One more time. I know, really. All right. This should work. I should have brought my kid. That's the truth. Why is this not? All right. Let's try if this works here. I did that. All right. Now, here we go. Security for 20. Oh my gosh. I'm going to cry in front of you. This worked a minute ago. Well, we're going to go through my questions in a minute then. This worked before. Sorry guys, hold on. Otherwise I'm just going to go through the questions and torch you, which I may have to do. The entertainment factor might go away. Try this. Sorry, Samantha.
No.
Right.
You got any kids? Let Sam do it. She's younger than you.
Yeah. Try one more time here. All right, slideshow. From the beginning. That's going to get pretty annoying, I know. All right. It's not letting me. All right, we just may have to go through my questions the other way. Hold on just a second. All right, let's see if this works. If not, I'm just going to ask you guys questions. Nope, it's not working. All right. All right, we tried. Let me try one more. No, not working. All right. All right. I've got a backup plan. Hold on. Always be prepared. Always be prepared. And you get to see me with my fancy glasses, too. All right, let's try this. Next question. I'll ask the questions for you guys. A first-class letter sent with a certificate of mailing is also called a...
Certified.
I hear certified. I hear a lien letter.
Proof of sending.
What?
Post office calls it proof of sending.
Proof of sending, so certificate of mailing, is also called verified mail. Okay. So it's not certified mail. Certified mail, as many of you know if you go to the post office, requires the investment of up to $5 for a certified letter as compared to a verified mail letter, which is a first-class letter with a certificate of mailing. Georgia law, as we'll go through, includes the fact that you now have a method of sending your lien letters. Again, as a reminder, you don't have to send by certified mail, but you can send by alternative or verified mail, which is a first-class letter with certificate of mailing from the post office. Okay. Or email, and we'll talk about that in just a minute. All right, here's a question. A spouse under general common law rights is an automatic co-tenant of the other spouse's storage unit.
No.
Okay, you guys have dealt with that, obviously. Good answer. That fact that you hear from people saying that I'm a co-tenant because that's my husband's unit, you have to let me in, and there's an issue concerning I have common law rights, is not true under the aspect of Georgia law which requires proof of deed transfer to the property. So if you have that situation, you are only responsible to the individual tenant, the one tenant that you lease to at your self-storage facility in those units. Good answer. All right. Can a facility convert to credit card only? Is it discriminatory to require a credit card as a condition of tenancy? How many of you are doing just taking no cash, just have moved only to credit card? Anyone? Okay. You have. So you really want to know right now if it's discriminatory. That would be helpful to know now that you've already done it. And the answer is, it's not. As long as you identify for your customers and treat it consistently as to the method of payment, you could turn to a credit card only facility. So as we move to the world of, sorry for the managers in the group here, non-managed facilities, remote facilities, where people are using kiosks, or forget about kiosks, just your phone, as it moves to the ability to access the facility, pay, utilize its access, all with someone not there. The question is how would they pay would be limited to credit card likely. And is that discriminatory for those of the people in the world that don't have credit cards? The answer is no, as long as everyone is treated the same. So as we move that way, that's going to be okay. All right. Under Georgia law, an occupant is in default under its lease after... Don't be worried now. We talked about denial of access after 7 days, and what's that triggered by? By default. Now, default means when the tenant is late in making his payment. Even though the tenant may be late in paying after day 1, they're not in default under Georgia law. Default is triggered after 7 days. Again, now, We'll talk about when you can charge your late fee as a result of that default, because the tenant's late, but they may not be in default until 7 days. The statute doesn't say when you can charge late fees. Even the new statute we'll talk about in a minute. Although it would make sense to me, for simplicity for you and for identification for the tenant, that a late fee not be charged until after the 7th day. Okay? But the law does not say you can't charge a late fee for the failure to pay on time earlier than the 7 days. That's up to you. I guess the recommendation again would be after 7 days for the late fee. Okay. All right. Can an operator require, Alana's going to love this question, can an operator require that the tenant have insurance for their stored property?
Yes.
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 Absolutely, clearly the answer is yes. You can require your tenant to have insurance for their stored goods. And I would amplify what she said, that it helps you to have your tenants have insurance as part of their storage of their property at your facility. Because as you showed with those great videos that worked as well as my program, I'm glad we suffered together here, things happen at your facilities. No matter what you do, no matter how perfect you are, things will happen at your facility, and there will be claims, and to dissuade a customer from coming against you, to go to the tenant insurance. All right, what about liability insurance for your customers? So let's talk about the fact, and I noticed that you guys had that when you put up your slide, the difference between property good protection for your customers' own goods and requiring them to have liability insurance for things they do to you or other tenants on the property. Right now in self-storage, and maybe Alana you can answer this, I would hazard a guess that almost nobody has their tenants get liability insurance at their facilities. But how many of you, I know how many of you have called me and said, what do I do about the tenant who just backed into my building, right? Who's damaged the door, who's damaged the gate, who's damaged the fence? Where is my claim for them? And what can I do to them? Well, you can ask them for the money, for the cost of repair, and maybe they'll pay it. I got some laughs on that one, I know, yeah, okay. Maybe you have to go to small claims court and sue them. But if they had liability insurance as part of their tenancy at your facility, then you could go to their insurance company for the liability they caused you or others. Yes, sir?
Most of those that you said would be auto liability, and if they had regular liability, it probably would cover that anyway if they did it for auto.
Well, they would be covered by auto, right? So another example would be if they, this is one that I thought recently, if they had that propane tank
Yeah, I was going to say stored propane.
and caused a fire to an adjacent tenant's unit, that their liability would cover the loss to your other tenant. So in situations where things happen caused by one tenant to another, and that tenant who's been damaged comes to you, there would be liability insurance. I'm only saying this because I know that you're cost sensitive to your customers, but it wouldn't hurt you to make sure your customers understand the difference between property protection for their goods as well as liability insurance for the facility and other tenants. If any of you have been involved in residential apartment rentals or anything like that, it's a requirement that your tenants have liability insurance, separate from their goods, covered goods. And
doesn't our rental agreement say that they are responsible for any damages they or their guests cause to the property?
yes, so the contract would give you a contractual right to go after them, no question. The issue is,
we collect from all of them.
you do?
Yeah.
Well, then you all be talking to Ann about getting these tenants to pay. The problem is some of these tenants maybe don't have the money, and therefore you have a ability to recover from the insurance company under the liability coverage. It's just something for you to think about. It's not going to be something that, as we grow as an industry, as we become more sophisticated as an industry, I mean, we didn't talk about even the concept of tenant insurance really as a condition of tenancy at our properties until the last 5 or 10 years, when you made nicer properties, right? When you were building your 3rd and 4th generation properties, and these things are more of an issue for you, the same thing could happen with liability insurance down the road. So you can require it. All right, once bidding begins on a unit, the auction cannot be stopped unless the tenant pays the amount due in full.
No.
Okay, sounds like we got people with experience on this. All right, so you say the auction cannot be stopped until the tenant pays in full.
No, it can be stopped.
It can be stopped. Okay. What would stop a sale in the middle of a sale for a tenant who owes you money and you're in the middle of an auction, whether online or live?
The tenant pays the.
Tenant pays the bill. That's, yeah, absolutely. Tenant pays the bill. Absolutely. I mean, that's the easy one. I'm not even thinking about
You
that.
find some sort of mistake.
Yep.
You find some sort of mistake in the middle of your process. Hopefully, you found the mistakes before you even put that unit into the system for the sale. What else? Bankruptcy. Bankruptcy notice. You received the bankruptcy notice from the tenant. Must stop the lien sale. Okay.
Military.
Military. Thanks, Sarah Beth. A notification that your customer is active duty military. And then the last one is just for you to understand that you have the discretion to stop the sale when the story hits you to stop the sale. You don't have to, and the reason I bring this up is because the people that are bidding may complain, hey, this is a good unit. You can't stop the sale. I'm in. I want this unit. I'm buying this unit. You've advertised it. I showed up. I get to buy that stuff if I'm the high bidder. The answer is no. Every sale is with reserve for your ability to pull it for the reasons we talked about, including your own discretion of the unit. If you have that little heartstring that goes to pull that unit, you can pull that unit even if you're in the middle of the auction.
And even if they win the auction?
Yes. Even if they win the auction. Okay, so if a tenant, in the bid rules, if a sale is concluded and you have a high bidder, but one of these other issues come up, not anymore your heartstring, but a true mistake in the auction, bankruptcy, active military, you can pull the auction until payment has been made by the buyer and possession of the property has occurred to the buyer. Sales can always be stopped. Money exchanged for property. All right, let's try. An operator may charge a late fee each month that a tenant fails to pay its rent.
Yes.
Yes, yes. And here's this is the big reveal. It was a lot more exciting when I had the video. I'm gonna sue myself later on this one. The law changed on late fees. Anybody know when?
July 1st.
July 1st. July 1st. I'm only a couple days late being here for you. What is the new law for late fees?
20% of rent or $20.
Whichever is greater. Understand the background of why this happened. The issue of what you were charging your late fees, whether it was $1 or $50, was subject to scrutiny by a tenant suing you for the sale of their property, claiming that what you were charging as a late fee was unreasonable and unfair, unconscionable, that your late fees exceeded the rent, that your late fees put an undue burden on them. Now, by law, and we now have this in over 30 states where we've supported the law to be changed, a late fee safe harbor law that allows you as a facility operator to charge $20 per month or 20% of the monthly rental rate, whichever is greater. Now you have to elect. You have to let them know what you are charging. Now, we've known this has been coming for a while, so I believe many of you have already been charging, because you knew it was coming, the protection of the $20 or 20%, whichever is greater. Some of you have utilized the system to charge the percentage. Some have limited, for simplicity, to your customers who can't do percentages, which I know has happened, to the $20. That's fine. For those of you who have not, welcome to the new law. $20 per month or 20% of the monthly rental rate, whichever is greater. If you are charging more than that, and you haven't yet updated your rental agreement, that's fine. You just can't charge. You must change your system now. If your tenant overpays on their late fee, they get a credit. Okay, that's just the reality of that change now, effective July 1st. You knew it was coming. Here it was. It should be in your system. Any questions on the new late fee?
Scott, you
Yes.
said you have to notify them. How do you notify them? In writing?
How do you notify them? Well, when you say notify them of the new late fee, if you haven't already done the $20 or 20%, yes. If you're going to change your late fee to a different late fee, notifying them of the change of terms, you would send out a written notice. It can be by email, letting them know that the law has changed and the effective late fee now is $20 or 20%, whichever is greater. That would constitute written notice. For those of you who don't have email addresses for your tenants, you would send a written notice by mail.
30 days is still required, right?
Well, no, the law takes effect now. The burden of sending the notice, yeah, I mean, you're just letting them know that the law has changed. So let's talk about your leases. So hold on one second. On the lease, there is a language change to the lease. It consists of about 6 words that need to be changed in your lease. And it really doesn't worry me for y'all to rush back and change your leases today, but it does, well, we'll be updating the Georgia self-storage standardized lease for you to know what that change is, and you can update your rental agreements without notification of change, because all it talks about is the fact that you are now including late fees as part of the charges that you can charge your customer as part of the sale. So it's a very minor written change to your lease. You can do it over time. The most important thing is you do not overcharge your customers after July 1st. Sorry, question? Yes, sorry.
On your 20% or $20, does that have to be across the full spectrum, or can it be applied to individual units? One or the other?
It's a fair question. Could you do 20% to one person and $20 to the other? I'd say no. I would create a consistent calculation of what you're going to charge all of your customers and not specify, I don't like you, I'm doing 20% on you, which could be dangerous. Consistent treatment of your tenants all the time is the way to go.
What about unit type?
By unit type? It could be, but I mean, I think it's a software disaster. I don't know if, are any of you charging different late fees based upon size of your units? I mean, you could. That would be a consistent action based upon unit sizes, but I think it would be I'm not sure any software can handle it.
And per unit, so if the customer has more than one unit.
Per unit, absolutely per unit.
The people that were already late before July 1st, we don't have to go back and change those late.
Right, it's after July 1st. Yeah, it's after July 1st. All right. Lien notice is sent by email. We talked about the answer is yes, email. What I do have here is the language of the statute. Any of you are sending your lien notices only by email? Only by email? No, really? Wow.
Still going to use the RPOS or something?
Well, yes, exactly. If you're sending your lien notices only by email, the statute requires that you get a verification of receipt or delivery of that email, and you need to use a third-party service. I know Storage now has a service. RPost has a service. You need to use a third-party verification of the delivery of the email. Basically, the legislator said, hey, great, we'll let you use email, but different from sending it by mail. If you're going to use email, we want to know that it was received at that email address. It doesn't have to be opened. Don't have to prove that they read it, just that it was delivered to that email address and not rejected. So that's why these third-party services popped up if you're using email. I'm really surprised to hear that not more of you are using email. If you're not using email as the sole notice for your customers' lien notices, I hope at least you are supplementing and sending by mail and email the opportunity to do both. Is that a yes back there? Good. So, because as we all know, the reason we added email to begin with was the fact that your customers are more likely to get their emails than their mail anyway. So please utilize that statutory right that you have to do the email. All right, if a tenant's unit is discovered without a lock, must the operator overlock the space?
No.
Without a lock? I hear no.
Yes.
I hear yes.
Is it past due?
You use the term overlock.
I use the term, well, without a lock. Must you put a lock on a unit that you find unlocked? I don't sure it really matters whether it's paid up or not, although you're probably less concerned about the people that haven't paid, but...
Do you require it to be locked, and the tenant doesn't have one? You should overlock it for liability purposes, nothing else.
All right, so your point is 2 points. One is, how many of you require that they lock their units? Every hand must go up. You cannot have your tenants rent a space and not lock that space. That's basically saying I'm going to pay $100 a month to put my stuff, but I don't care what happens to it, right? Because that, to me, that's just like a garage sale opportunity. So,
Your unit, you're giving the customer the right to not lock their unit because they know you're going to do it.
well, yeah, but she's saying if you don't lock it, something you're gonna overlock it, and they go away. Hey, free lock.
But the lease requires it.
Lease requires a lock. Make them lock their units. To me, the answer that, and I bring this up because of the fear factor of, if I overlock a unit, do I take a bailment over that unit? Do I create care, custody, and control when I find a unit unlocked and I lock it? I want to make sure you feel comfortable about understanding the courtesy of an overlock as compared to, hey, that unit's unlocked, I'll come back tomorrow, see if it's still unlocked, and between that time that you knew that it was unlocked as part of your daily lock checks. Do we need to talk about that too? That you have confirmed that you have put a lock on that space so it's not available for anyone to go in, and you have not created a bailment. You've created a courtesy opportunity for your customer to come in and put a lock on it. Now, customer, of course, you're going to tell me, what if they don't come in and put a lock on their unit? That's never happened to any of you, I'm sure, right? Okay. Yes, you can overlock the unit. You can put a lock on the unit and charge them for the lock. That's addressed in your rental agreement as a right for you to charge them for a lock and put a lock and mail them the keys. All right. All right, let's go. All right, if a high bidder pays the online service its buyer's premium, but fails to claim the property, the operator is not permitted to sell the property to the next highest bidder.
Negative.
Negative. Now, are you guys using online lien sales?
Yes.
Some of you, all right. And you understand they're paying a premium for that bidding opportunity, and we have certainly situations where those bidders have paid that premium and then decided later on they're not going to come and get the stuff, or haven't come within the allotted 48 hours or 72 hours to get their stuff. So what do? Do you have the right to go to the next bidder as part of your bid rules when they don't show up, even though they've paid that buyer premium? And the answer is yes. And if you have any concerns about the clarity of that, go back and look at your bid rules with the online provider you're using to make sure it's clear for you and for your bidders to know that if they don't come within that 72 hours or whatever you've given them, and I will tell you, that's left to you. And all the bid rules that we see, it's left to you as the facility operator to decide whether you're going to give them 24, 48, 72, or a week. They don't need a week. But you can't give them.
With that rule right there, though, because, you know, if you sell a unit for more than what's owed to you, you have to put that money away. So if you sell that unit twice, you still got to put the money away, right?
You sell that unit, you're selling it, you're effectively selling it, well, I guess you could say you're selling it twice. Whatever the proceeds are as a result of the sale, yes, the tenant is entitled to receive those proceeds. All right. There's a lot more visual other than me up here with my video slide here. All right. All right. A facility operator must provide access to any tenant that has paid its rent at any time, or the operator has committed a criminal conversion of the stored property.
No.
No. Okay. You have gate hours. You have office hours. Those of you who choose 24-hour access, all right, raise your hand. 24-hour access. Oh my gosh. Do you like it?
No.
I hear no. I don't need to see my couch at 2 in the morning. Maybe some of you do, I don't know. 24-hour, tell me that someone who does 24-hour access and loves it, tell me the benefit of 24-hour access. Yes?
Well, we do everything remotely. We don't have an office out there.
You don't have an office, so they can come and go whenever they want.
Yes.
Any problems?
No.
No? Now that we talked about it, so, now I'm worried. Yes? 24.
For a long time, we've had more campers than units, so the campers will come from vacation and 12 days or whatever, or access there, but we'll trip.
Okay, so you need it because people will come and go in the middle of the night with their campers. Okay? All right. So some people have any other?
Yeah, facilities that are unfenced. It's not hard to stop them.
It's not hard to stop them. Certainly with an unfenced facility, it's not hard to stop them. Absolutely. All right, so access is access.
Commercial tenants.
Commercial tenants. Okay, so now there's been discussion of the fact that if you have particular tenants that need 24-hour access, you can by addendum provide them 24-hour access. You have the software capable of doing that for an additional value for that access, and limit the number of tenants that have access to your property 24 hours. That may be something you can think about. The issue for me legally is a tenant who's paid the rent that calls you and says, I want in, let me in, or you've stolen my property. You've created a conversion of my property. I have the legal right to get to my property. You can't keep me out. Come during office hours. Come during gate hours. Okay?
Yeah, because the rules are part of the rental agreement.
The rules are part of the rental agreement. Now, here's an element of this. You have someone that you believe has been sleeping in your unit.
Call the police.
Call the police. Okay, call the police. That's fine. Can you control access to a tenant who you believe is breaking the terms and conditions of your lease? Can you control access
Yes.
by having them come to the office and you letting them in? Is that a conversion of their property by controlling access to your facility?
Nope.
No.
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 Louder!
No.
It's your property. I don't want anyone to be afraid of the situation where someone who's breaching the terms of the lease and you go, ooh, I can't lock them out. They paid their rent. No, they violated the rent terms and conditions. You can't overlock their unit for that breach, but you can control access to your facility by denying, if you have a gate access control. Okay? That's your ability as the landlord in a tenant situation where they have to be responsible for the terms and conditions. All right. Here's a good one. Security. Bluetooth locking systems constitute a bailment since the owner has the ability to remotely lock and unlock the tenant's unit. Bailment. Care, custody, and control. Does the fact that it's an electronic lock that you can open and close from your house change your role as a landlord not having bailment over their property? No. I want to make it clear, this question has been coming up a lot because we have companies out there that are now offering Bluetooth locking systems, so there's no lock on the door. You have your phone, you open the unit, you close the unit. If you don't pay, they take the code out, right? They can control the access. Does the ability for them to control access to that unit change the definition of non-bailment and self-storage? The answer is no. So I don't want you to be afraid of the world we're entering with Bluetooth locking systems or Bluetooth gate access systems. It's absolutely fine. Maybe you want to address the clarity of how those systems work in your rental agreement. That's fine with me. Maybe a notice in your office about the unique attributes of a Bluetooth locking system as compared to a regular lock on the unit. That's fine. But do not be afraid that that has changed your role in the self-storage industry to that of a bailor over the property. That's not the case. All right. What defines a commercially reasonable lien sale under Georgia law? How many bidders do you need at your auctions, either live or in person? Three. Three or more. Three or more what?
Not related.
Not related. Independent bidders. Good. So, Joe, his brother Joe, and his other brother Joe cannot be your bidders at your self-storage auction. They can't be all from the same company. They have to be independent bidders, and that does not include you as an independent bidder at your auctions. The solution for this determination of commercially reasonable lien sales by having three or more bidders has been solved a lot by online sales where you have multiple bidders at the lien sale. All right. All right. I know you guys would have been more excited if there was money involved, but you're doing fine. All right. Employees, it's a good one. Employees with concealed carry permits can have their gun with them at work.
It's up to the owner.
Is it in the,
how many of you are carrying right now? I don't want to know. Well, all lawyers are nice. Let's be clear about that. Yeah.
I know.
Respecting the right that you have a concealed carry permit individually does not, Kevin's right, does not allow you to have it at your self-storage facility unless your facility operator or you have decided that that would be appropriate and okay at your facility. Otherwise, you have the right to restrict any guns at your facility. Just be clear. I mean, there's laws in Georgia that very clearly determine what rights, including, now this is an interesting aspect, the fact that you can keep your gun in your car at the facility in the parking lot, okay, but not bring it into the office, and you have the legal right to do that, unless the owner indicates otherwise that you can't have it even on the parking property. And I know this issue's come up in terms of safety and security for some of you at your facilities, wondering what your rights are to protect yourself. It really is governed by law that the owner can control whether guns are allowed on the property or not. So it seems like you guys are familiar with that. All right, must a tenant provide their social security number? Oh yeah, I'm sorry.
What is your thought on allowing them to do that?
My thought on allowing is the fact that I'm going to get in trouble for this. I mean, statistically, my understanding statistically is that companies across the board, even though there's been some company, office and warehouse shootings recently, so people would have raised the question if they had guns to protect themselves, maybe it would have happened. But statistically, their point has been that it's safer not to have any guns in the workplace.
Bullshit.
I know. I knew that. I knew I was going to get that. Because because sometimes people can get angry.
Cobb County.
Like if he had a gun right now, I'd be dead. That's it. And I'm not rendering an opinion. I'm saying that these articles that have come out about the right of an employee to have a gun in their workplace overriding the interest of the owner because of their own protection has been the fight, and that's why the laws have come out that said the owner can dictate whether guns are allowed at the facility, even if you have the right to carry the gun under a carry permit. That's where the stress has been, the employee wanting their right even in the workplace. So it's an owner decision, and then depending how the owner feels about the protection of their employees, absolutely up to you. Kevin, did you have a...
Well, you might want to check as an owner your policy, the liability, make sure that there's coverage for that if you do allow them, because you may not be covered for some kind of liability rising up.
That's interesting. So your insurance may not cover it if you allow it.
Yeah, if they carry, they may want to have their own carry concealed liability, which a lot of people do buy that carry.
Okay, something to think about. Yes?
I got a question. When you're doing auctions, and you're doing live auctions, instead of, you're doing them in person on property, what about protecting yourself from bidders coming in with guns on their personal possession?
So you have the right at the gates of your property to restrict people coming onto your property with or without guns. You'd have to post that at your property, and some of you have posted that no guns are allowed on your property, and that would be true for your lien sales as well as at your lien sales. If you felt the need to have security at a live lien sale, you could of course make the decision as the operator again to have the right to have a gun at the lien sale or hire security at your lien sales, which has been the solution that many of you have gone through. In fact, what has been the motivation in a lot of instances for the success of online lien sales is the fact that you guys were tired of the stress of the live lien sales and all that cash around, and all the fact that there were, in fact, the challenge of some thefts at the property at the time. So you can have restriction at your facility, no guns, posted at the gate to not allow guns on the property. Now, I want to add a little anecdotal story here. We were recently dealing with a case where a tenant, this is a crazy case, but a tenant was blocking another tenant's access to its unit. Tenant got very upset. In fact, had an altercation with the tenant's mother, which apparently made it worse because that tenant left the facility, came back with a gun, and shot the tenant at the facility. The facility now is being sued for negligence in allowing crimes to happen on its property, which I don't think it ultimately will be held liable for at all. But the fact that that's an instance to remind you that these things can happen at your properties, because things can happen anywhere. I'm sorry? Oh, absolutely. He went back and got his gun. Yeah, it was pretty bad.
So would it have helped you if you had it posted that no guns are on the property?
It wouldn't help the guy who got shot, but it would have helped, yeah. It would help the facility, yeah. No. And look, the truth is that the facility, yeah, absolutely. Yeah, I think that would have been a nice added defense if the facility had signs posted about no guns on the property. Interesting point. All right. Is the $5,000 limitation of value provision in the lease legal? The reason I bring this up, and Alana mentioned it as part of your insurance programs, many of you have insurance. They could have 2,000, 3,000, 5,000 choices of options, right, or more. The issue for you is the $5,000 limitation of value provision that's in your rental agreement. Not only is by law, by case law supported that you can limit the value of the goods being stored by your customer, which limits your exposure to liability for the loss or damage to that property, but based on the last legislative change, we now have it clear by statute that if you have a limitation of value provision in your rental agreement, then the tenant is governed as the maximum value of the property that they can store without permission from you to store additional. Now, I get this question a lot. You have a tenant come up with a couple moving trucks, and they're moving their gigantic house into your multiple units, each at a $5,000 limit, and come to you and say, I want to increase the value. I see it's $5,000 in the rental agreement. I want to go to $10,000. I want permission to do that. Can they do that so they're not limiting the value of the property stored to the $5,000? The answer is yes. But please, if you are allowing a change to your rental agreement on the limitation of value, you require the addendum that goes with it that requires your tenant to have proof of insurance for the higher value that they're requesting. So you can increase the value, but you want to make sure there's a match of the insurance that goes with it. Now, some of you may not even allow them to change the value. That's your prerogative. Maybe the tenant won't get up and leave if you won't change that rental term. But you have the right to change it. But you also have the right not to change it unless there's insurance that matches the increased valuation that the tenant is asking for. Otherwise, you should be limited to a risk of liability $5,000 per unit. Now, one thing I want to add is that goes to the question of the value of the property. If you do something to your tenant's goods that's intentional or malicious, that $5,000 is not going to help you. If you get into a situation where you dispose of a tenant's goods, some of you may have been there, dispose of the tenant's goods without following the lien law, the tenant can make the claim that your acts were such of a grossly negligent manner that the contract limitations would be thrown out by the judge. So you have to be very careful that if you're ever dealing with disposal of your tenant's goods, it must be clear from the tenant they've abandoned the property, or you've gone through the lien law, or you've made a clear determination that the property in the unit has zero value as judged by someone else other than you. Yeah?
What's the purpose of the 5,000 limitation if the whole lease is designed to say we're not responsible?
So the whole purpose of the 5,000, even though the lease says you're not responsible, is the fact that I don't care what the lease says, tenants still sue you. And because of that, if you have the ability to also limit the damages that they're claiming, it'll reduce the likelihood of the extent of the lawsuit that's being brought. Just because your lease says you're not responsible for loss or damage to your tenant's goods, and many of you have experienced this, tenants will sue you anyway. But the fact that you can limit the damage of that potential lawsuit to the 5,000 as upheld by the statute is a really good defense for you as self-storage operators. So just keep that in mind. That's basically the backup protection. All right, a couple. Yes, sir.
You just made a statement that I want to ask you a question about.
Yep.
You said make sure that the lien process has been followed or the unit was abandoned. Could you differentiate between those two?
When I use the term, the question is follow the lien or the unit has been abandoned. When I say abandoned, the tenant has abandoned the property to you in writing. Now, writing these days can be email. I would even be comfortable, not loving it, with a text, which is, I don't want the crap, it's yours. God, you guys really don't get me anymore. All right. How many of you have ever gotten a text like that? Come on, close to it. Thank you, thank you. Okay, yeah. That, to me, when the tenant says, I'm done with my stuff, you can have it, is an abandonment that if the tenant comes back later and says, hey, where's my stuff, you have the writing, the text that hopefully you've copied and printed out somewhere, that says the tenant's abandoned their property. That, to me, is the key to protecting yourself as compared to a phone call or a conversation in front of the unit where the tenant says, I'm done with this, and that could be ambiguous and they come back later. So in writing an abandonment or a lien sale.
Our lease also has an abandonment clause. If the no lock and no money, and we give them notice, and they don't respond to the notice, we abandon it.
True. Again, just all these provisions of your contract are to respond to the worst case scenario of if you haven't done a written abandonment and the tenant comes back later, that contract's a defense. Hey, it says in the contract, you haven't paid, you took your lock off, we've abandoned the property. But to avoid even the argument of abandonment, to have the tenant confirm it in writing is the key defense for you guys to use. All right, I'm not going to talk about towing. Well, let me talk about it for a second. How many of you have now moved to towing cars and boats in lieu of lien sales to make your lives simpler? Okay. I do want to make sure that you know that the issue of a tow of a car, boat, RV parked on your property pursuant to a self-storage rental agreement can be towed after 60 days in lieu of going through the DMV and trying to get title to the vehicle in your facility's name and selling it with title or selling it without title for parts only. All the stress of dealing with title property has gone away by that change, knowing that your only requirement for a towing option is after 60 is as part of your lien notice, putting in your lien letter that after 60 days the vehicle will be towed instead of sold. And that, using your lien letter the same way that you use your lien letter for a lien sale, having that lien letter clearly say in lieu of sale, it will be towed. and you have the right to have it towed by a tower. Anyone having troubles? I've heard this come up a little with tow companies taking the property from you, or we're good on that. Georgia's been pretty good on that with the tow companies being cooperative. They make money on this. I mean, ultimately, if they sell the vehicle, and this is what tow companies do to make money, they get money as a result of that lien the sale that they go through. So,
I know in Cartersville, they prefer you, when you do that, they want you to call the law first to have them run the VIN number first to make sure there's nothing, no investigation or the car is not stolen before they tow it off.
okay, so that's to work with the local police on verification with the VIN that it's not stolen before it's towed. Great.
Right.
Yeah. Yes.
I've got a a tenant in auction status. In the unit is a motor scooter. Can I take the scooter out, put it in another unit, go ahead and sell his unit, then follow the guidelines of towing the vehicle after 60 days, have the vehicle?
Okay, so the question goes to, can you segregate out of a unit filled with personal property and titled property to sell the unit with the personal property and then later deal with the titled property? And the answer is yes. You can segregate out property. You don't have to sell it as a whole. You can break it up. You can sell the personal property. It may be as a result of that sale of the personal property, you've paid they paid the debt that's due and you hold on to the scooter. But otherwise you would have the right to tow the scooter after the lien sale by segregating the property out of the space. It happens a lot when some of you go into a unit and you're going through the stuff and you realize there's a car back there. Well, can you still go through with the lien sale? The answer is yes for everything other than the car, and deal with the car either by sale or by towing later on. All right, let me do a couple more here. Upon notice that a tenant is deceased, the facility operator is required to overlock the unit and deny access to all parties until a proper court document is provided along with a valid death certificate.
No.
That's true, not false. Wait. Not. It's like having to ask a question as part of the Jeopardy. The answer is that people are allowed access to a unit of a tenant known to be deceased if they have the key in the code.
Right.
Yeah.
Yes. So you would not overlock a unit once you find out that the tenant has died. You would have the ability, if a party can access the unit without your assistance, to get into the unit, even though that you know that tenant has died. You're sitting and reading the paper in the morning, hey, that's my tenant, he's dead, and the family comes in that afternoon to access the unit. You're not going to throw yourself in front of the unit and overlock the unit and say, hey, I saw your dad's gone, so you can't get in. The problem we have for you guys is when families come to you and go, hey, I know he had a unit here, I don't have the key in the code, I need to get into the space. And that's where your duty of requiring them to have the court document and have the proof of death by death certificate is for your protection before you let people in. Because there could be issues of competing claims and things like that. So that's where that level of requirement comes in. When you get involved with access to the unit is when you want the paperwork. It's our question.
If the tenant is delinquent and was already overlocked, what do we do in that case?
Well, if they want to access the unit, again, with their ability to access the space by gate code and lock to the unit, if they pay the rent, they can access the space.
But they have to pay the full...
Oh, they have to pay. You have to pay. You don't have to let them in. You could let them in. You could, again, that heartstring situation would be, I'm sorry to hear about your loss, forget about last month's rent, and you would take your overlock in off, and they would go in with their access. Other than that, you would control access. Yeah?
Do you need any specific, you say court documents,
Yeah.
What kind of court documents? Because before we just use just death certificates.
Okay.
And if it's emergency contact, we have usually two contacts. If it's one of those two people, typically we would say you're fine.
Yeah, so I want to be clear on the court document. What I'm looking for is, and this would be something that your tenant's family would need in general circumstances, not limited to self-storage. If they have a safety deposit box, a bank account, a car, a house, they're going to need something from the court to give them authority to act on behalf of the dead person. And that typically is an order of administration from the court. The family goes to the court, files the will, the court will approve someone to act on behalf of the estate, and that person would have an order from the court called an order of administration. That is what would be presented along with the death certificate. In lieu of that, if they don't have a will and are not probating to file the paperwork, there's an alternative called a small estate affidavit, which they could sign and present to you, which is a sworn document that says they are acting on behalf of the deceased tenant, and you're able to rely on that sworn document as immunity for you if you let them in, because they've provided that sworn document to you. I saw back there. Oh, small estate? Okay, all right. All right, let me do one more, and then I'm going to leave it open for questions. A government subpoena may be issued by an investigative agency like a DEA or DOJ without a judge's signature. How many of you have received subpoenas from the government recently? We saw a rash of them just a few weeks ago. All right, nobody here. So the issue was, hey, this is not signed by a judge. This is out of the DEA to ask for these tenants' files. Do we have to respond to this subpoena, and it's not signed by a judge? And the answer is that the government does have limited subpoena power and can present you with the subpoena for those records without having to get a court order. So you could look at that and raise questions as to the legitimacy of the document. I still want you to ask the right questions. If you have any concern over the legitimacy of the subpoena that's being presented to you, you have the right to inquire. You have the right to say, who back at the home office can I call to verify that this is accurate, if you believe that this is somehow something, a sham of some point. But what I get is typically a question of, I don't see a judge's signature on here, and therefore, is it valid? And the answer is yes. And I really want to remind you that only because I don't want you to get in disputes with law enforcement that come to your properties looking for records of your customers. In that same vein, when they come with the subpoena and they're looking for records on a tenant at your facility, but they don't want to tell you who that tenant is, but they want to issue a subpoena for all of your records, you do have the right to come back to them and say, that is an overzealous subpoena, overburdensome on us, it's time consuming, it would take us a long time to go through it. Please let us know who you're looking for, and then we can pull the records specifically that you're looking for to speed up the investigation. So you have the right to cooperate with them to narrow the subpoena request to help everybody. So it's a matter of conversation, and those of you who for a while there, we're getting a lot of DEA subpoenas, and we're very worried about it. Look, it's not against you individually. At least I hope not. Some of you who are doing stuff on the side, but no, the subpoenas are looking for records of your customer. Clarifying as one other point the fact that a subpoena is not a document to allow access into a tenant's unit. A subpoena is for the documents, a search warrant is for access into the unit. If law enforcement comes with a subpoena and says, and finds in the records that John Smith is a tenant in your facility and then seeks to enter that unit, you have the right to ask for a search warrant. Now, they have the right to say, get out of the way, I'm going in anyway, but you have the right to ask for a search warrant because the subpoena by itself does not allow the access rights into the unit under the Fourth Amendment, rights of protection. So, all right. I promised it would have been a lot more cool. I had some good audio for you and video, but all right, now I want to just, before you guys run, I want to make sure I answer any other questions for you guys, again, the change in the lien law is limited, but it's effective now, so I want to make sure that you understand that change, as well as anything that's going on in your properties. Yeah?
Yes, I purchased the facility. I had some tenants that have units that were locked, and with no records of the tenants that's in that unit.
I hope you got a good price. Okay, all right. So now your question is, what do I do with those units that I don't know who they are, what they are, because I don't have any corresponding leases or any information?
Correct.
Okay. Some of you have heard me answer this before because I like to call these my Columbo units. I picture Peter Falk and the hat and the overcoat, cutting that lock and going in that unit to discover whatever you can about what's in there. You have really an unknown unit. You have the responsibility to perform due diligence to see if you can discover whose property that is before you do anything with regard to the disposal of that property, including going back to the prior owner and saying, who was in Unit 101? I mean, there's got to be a story, somehow a backstory to how that unit's been occupied. It may be that they don't know. We've had situations with unfenced facilities where people go, hey, that looks like a nice self-storage facility, I'm just going to put my stuff in there. Has that ever happened? Yeah, absolutely, yeah. That's why there's fences, and a lot of you have fences. Is that belief that people can just put their stuff anywhere, and that may be a situation where there may be a backstory. But you want to go in, you want to evaluate the value of the property. I mean, if it's unusually maybe high value items, these are not things you're just going to dispose of, or it may be trash. And I would invite you to have a third party appraise the property with you, provide a written appraisal, take pictures, create an inventory. But if that unit is not paid for and there's no lease, over a certain period of time, you're going to have that unit disposed of, unless it's a high value item. And then you're going to have to look at other maybe notifications in the paper, you know, who has a unit 101 at our facility, and see if anybody responds.
And then notification, I would do the notification route. How many, 30 days or something like that? Or?
Well, you know, my issue on this is not to act too quickly about disposing people's property, period. So I would, you know, I don't know how long you've owned the property, but
6 months.
How many?
Like 6 months.
6 months, and you haven't got any rent allocated to that unit or anything.
No. And some of the locks have been, I can tell that nobody's been in because there's an old rusted lock on it. I just didn't, you know. Okay.
Well, you have the right to go in and investigate, and let's see what happens as a result of that. But other than that, after you give notice, it's 30 days. Yeah. You had a question? No. Okay. Yes.
Just to confirm, okay, so current tenants before July, we can keep those late fees on there if they required like more than the 20?
Yeah.
Or 20%. So, and just going forward with the 20, it's only one time.
One time
and it has
per
nothing
month.
to do with the lien fee.
It has nothing to do with the lien fee. Yeah, so it's a great question. So we've now created the safe harbor for the late fee, understanding that after 30 days, whatever you charge for doing the inventory process, for the advertisement for the sale, for the sending of the letter, for the conducting of the auction, the seller's premium that you pay for the online service, all of those fees can be charged to your customer independent of the $20 or 20% without any cap. So you have the right to charge those lien fees independent of the late fee. Cliff?
That 20/20 can be split up though. It can be 10/10, 10/10.
Yes, you can divide it 10/10, absolutely. With, you know, $10 after 10 days, another $10 after 20 days, all after July 1st. Yep.
So I've got a tenant that's an accountant. We can't get in touch with her anymore and have to inventory her unit, and there are boxes and boxes of social security numbers, everything like that.
Okay.
What do I need to do? Can I sell it at a public auction? Even though I know it's full of personal information.
You be my jury here. He's got a unit filled with accountants, customers' files. Do I hear our first bid?
I've got 2 units full of lawyers' files.
Lawyers are worse. Lawyers and accountants.
So calling up your shredding service and having it shredded right there.
Well, you're ultimately going to get to shredding.
Is there an accounting?
There is an accounting board. Yes.
Like
So what I was going to say to you is accountants, like lawyers, and maybe even better than lawyers, are licensed to be accountants in the state. And you can go to the accountancy board, notify them about one of their licensees abandoning their records, and that if they haven't already been disbarred as an accountant, or the accounting firm hasn't closed or whatever, they could lose their license if they don't take fiduciary responsibility for their records. It's true for lawyers, doctors, insurance agents, whatever. So I'd call the board, because if the board calls the licensee and says, pay for those records and take care of your records, and they don't, they could lose their license.
Well, a little background, they were in the newspaper, they've been arrested for stealing $100,000.
Well, now you know where they are then. Okay. All right. So ultimately, you can do a lien sale. You would go through the lien sale process. If they don't come, you would send the letter, you would publish the ads, giving them an opportunity to cure up until the day of the sale. At the day of the sale, the unit goes up and comes back down. No sale. You can't sell customers, clients, patients' records. And then you would have it exactly that, shredded, get a receipt for the shredding, and that would be a cost that you could impose on that tenant. You'll never get it, but because they're in jail. But you could charge it. You cannot sell third-party records in that instance. Steve.
Hi Scott, thanks for bringing it up there. So I have some questions about the lien law, so I get it straight. You said there's like 6 lines that we have to send out to all of our tenants.
6 words. 6 words.
And are those words in these documents that you sent out that we received?
It is contained in the, if you received a copy of the new law, you will see the required language, the bold, capitalized language.
Marked out.
Well, I'm not worried about the change of e-mail to email. I'm not worried about that. there is required language that needs to be in your rental agreement, that you'll see in your rental agreements. It's capitalized, bold language about the lien sale. And you'll see that there are 6 added words that say you now can sell a tenant's unit for rent, late fees to be charged, lien fees, etc. And those are the additional, that's the additional language that the legislature required us to add to the leases. It's not, all it says is that you have the right to include late fees as part of your lien charges.
But you didn't say I had to add that to my lease for all the existing leases. I need to notify all my existing tenants. My new leases, because you issue the lease, we're going to get a copy of so we can...
Yeah, so we'll update the Georgia standardized lease. You can get a copy of that. For your new tenants, having the new language in there going forward, that's not a problem. For your old tenants, yes, you could send a notice. I'm not that worried about it. I'm not worried about it as long as you don't charge more than $20 or 20%. That's the difference. I invite you all to update your rental agreements, but to have to notify your current tenants that you can now charge late fees based upon this language. Great exercise for you to do it. I'm not worried if you don't. I don't want you all spending, sending out thousands of letters if you are worried about that price, but you certainly can do it. Yeah.
And the last question was, I know my U-Haul partners are here aplenty, LJ and all the rest. Someone's got to help us with the web self-storage software, so we tweak those for the 20 and 20%. $20, so that all comes out right since this is effective July 1st.
Right, so the question for you, and that's a good point, Steve, for any of your software providers, I have found, and I don't know whether they've solved this riddle, of the percentages as part of your rental charge calculable as part of the notices and all the pieces that go to calculating percentages. That's why many operators have just done the $20. It's a lot simpler, and it's a lot easier. It's not as much money recoverable, because a lot of you are charging up to, if you charge up to $200 on a unit, you're talking $40 compared to $20. So you have that right, but your software needs to match it.
And you're saying this is in 30 states already?
Yes.
So you all has places everywhere. They should already have this.
I'm not getting in the middle of this. You guys talk afterwards. Yes, the software should match the change in the law. Yeah.
So when we have to send notice, and you said it's not as important as long as we're following, can we just add it on as part of our late notice, like when they receive their late notice? Just have like a note on the bottom.
Great solution. As part of your late notices, include the language that's the change. That's a great point. That's an excellent solution. That's a good practical solution to the notification problem. Yeah.
Is it legal for us with the changes to the law to keep our previous tenants on the same structure they were already on, or do they all have to be converted?
They all change. Past tenants now, if you were charging more than $20 or 20%, as of July 1st, as a safe harbor to you, all of your tenants would now convert to that late fee. So hopefully some of you were charging $10 and now you're going $20. And I can do it legally. Some of you were charging $50 and going, this hurts. So, but I will tell you and I want to be clear about the fact that if you still want to charge your $50, you subject yourself to scrutiny that if you could prove $50 is the cost to you associated with your tenants being late, you could fight that fight. But this is the safe harbor that you can never lose if you charge $20, 20%. Yeah.
We send the notice that we're going to sell, we have to do a 14-day period before we start advertising.
Yes.
Is that 14 days from when we're verified that they've been delivered, or from when we send them?
So the question is, once you send your lien letter, you have to wait 14 days before you can run your first ad. Must the letter be delivered before that 14 days? And the answer is no. When you send it, it's deemed delivered. So you calculate your 14 days. Now I would start the 14 days the next day, and then add 14 days before you run your first ad. But the law no longer requires delivery of the lien notice before you run the ads. Yes?
Annually in Albany, we get a notice from the tax department, the Albany Authority Tax Authority, wanting the names of our commercial tenants so that they can levy against them if they have inventory stored with us. And to threaten us, with not giving information repeatedly. Yeah. What's that all about? And are we required to send them the names of our customers?
So here's a question. It may apply to some other counties here. It's a deeper fight that's happening. They get a county inquiry that requires them to turn over the names of their commercial tenants. as to what they're storing, so they can charge them and basically an ad valorem tax for what's being stored at your facility that they may not otherwise be disclosing to the government officials for tax purposes. There are privacy rights that I think apply to this that would require you not to disclose that information, but that's a whole separate discussion that we can have later. Is that if any of you fought this fight, though, this would be helpful as an association, that you've gotten tax inquiries from local governmental folks requiring information about your tenants to deliver. I would not deliver it by letter, it would have to come by subpoena. It would have to be a governmental subpoena for the disclosure of private information of your customers. It's a fight worth having. And other storage operators, I think, have already fought that fight. And that might be something that the association can help with as a local area. All right, I got 2 more minutes. Last question, yeah.
We have a situation where we saw someone under the camera using drugs, and it was...
You think... Well, I mean, I really would like to know how you knew whatever substance they were inhaling or injecting was drugs. That's a tough one.
But it was to the point where we didn't want them on the property anymore. Do we have any grounds to lock them out of the gate or overlock them just to...
It's a great question to finish with. I will say this until you all put me in the ground one of these days. Self-storage rental agreements are month to month, 30-day agreements. So the unique aspect of this industry is these are short-term leases. You have the right to not renew a customer with notice, and your lease agreement talks about 7 or 10 days, I can't remember, that you have 5 days. 5 days advance notice that you are not renewing their lease for the next term. You have that right. Now, maybe if you want to give more than 5 days, it's fine, but 5 days. Just the same way that your tenants have the right to leave your facility, to pack up and not renew for the next month. You have the equal right as the landlord to not renew that lease with notice for any reason or no reason. Okay? You don't have to disclose, hey, I saw you, what I think you were taking drugs, and therefore I don't want you on the facility. If you have any customers that you believe are breaching any terms of your lease, create any heartache for you, you send them a non-renewal of the lease. Now, I know what you're going to say. What if they don't leave? Yeah. Right? And we have that. Some tenants, look, I send a notice of non-renewal to 90% of you, and you go, they don't want me anymore, I guess I'm going to leave. I'm going to pack up and leave. You're going to be a proper citizen and respond to the notice and the terms of the lease and do what you're told. You may not be happy about it, but you're going to leave. And there's the other folks that go, they aren't taking me out of here. I'm going to stay. They can't. I have a legal right to be here. They don't. But you then would have to go through an eviction process where you go through dispossessory and get a writ of possession, and the sheriff comes and literally removes the tenant and their property. But I want you to remember, and it's a great way to finish, that it's your facility, your property. You have the right to control who your tenants are at your property based upon their behavior, not based on who they are, but based upon their behavior. So you're not going to turn away a person that looks homeless at your facility, but you can not renew a tenant who you find sleeping on your property. You cannot turn away a tenant because, unless you have established based upon the credit cards or whatever, but you can turn away a person who you believe is committing crimes on your property. That's your right as a facility operator. You will never lose in court where you terminate a tenant because of their behavior on your property pursuant to the terms of your lease agreement. So go forth, be strong, be an advocate for your properties. I'm sorry my presentation didn't work, but it's always a joy to be here with you guys. Go forth and tell a story.